Good evening. Welcome to What You Need to Know About Hemp in Texas. Tonight we're going to be talking about House Bill 1325. It was passed by a supermajority, signed into law June 10th, 2019. It's effective immediately. It's also known as the Hemp Bill. What is hemp? Hemp is the plant Cannabis sativa L and any part of that plant, with a delta-9 THC concentration of not more than 0.3% on a dry weight basis. What does House Bill 1325 do? House Bill 1325 directs the Texas Department of Agriculture to develop a plan to monitor and regulate the production of hemp within the state of Texas. The Department of Agriculture must submit a plan to the United States Department of Agriculture within 90 days of the effective date of the bill. If the plan is denied by the USDA, the Texas Department of Agriculture must amend the plan and resubmit until it is accepted and approved. So, you want to grow hemp in Texas. To do so, you have to have a hemp grower's license. It's required to cultivate, handle, or transport hemp in the state of Texas, as well as transporting out of the state of Texas. The Department of Agriculture will be developing the rules and the regulations that cover this program. Those regulations have to cover sampling, inspection, and testing, among other areas. That includes the laboratory standards and accreditation standards. The rules and regulations that are propagated by the Department of Agriculture must provide due process. And that includes an appeals process for any adverse decisions that the department may render. What's all this going to cost? That's the real question. That's what your clients are going to want to know. An application for a license is not to exceed $100. Renewals, which will be annual, are not to exceed $100. Each location under a license will be required to have a participation fee paid. That will not exceed $100. Testing fees that are going to be required by the state will not exceed $300. Site modification fees for any sites that are licensed and you change the premises will not exceed $500. The statute explicitly disallows any other fees except for two. Those fees will be to certify products as organic, as well as certifying seeds. Those fees will be announced later. Those are to be determined. So your hemp grower's license. As I said, it's required to cultivate, handle, or transport hemp. It is not required to manufacture consumable hemp products. We'll get to that later, the differentiation between non-consumable and consumable. The department will produce applications. That process is coming. A license will be issued. The department must issue your license within 60 days to a qualified applicant. These licenses will be valid for 1 year and renewable annually. They will be revoked for a felony controlled substance conviction, as well as will be denied. More on your applications. The applicant, as I said, cannot have a felony controlled substance conviction within 10 years prior to application. That's from the date of conviction. The application will also be denied if it's found that you falsified any of the information on it. We don't know the extent of the application, but what the bill does lay out is a couple of requirements. Applications must include a legal description of the premises. They must include written consent to enter and inspect the premises and the crops. That's going to be very important as far as compliance is concerned. You'll also have to submit all associated fees, and you cannot be past due on any other fees. You cannot owe the state any money, and you must include any other information that the department includes as part of the application process. Inspections. Like I said, this could be very important from a compliance perspective. You will have given written consent to enter and inspect, so that is going to authorize random inspections. This could be done by both the Department of Agriculture, whatever regulatory body or office it sets up, but also very important is the Department of Public Safety will also have the ability to enter and inspect your premises. DPS can refer cases for criminal prosecution should they see fit, and both Department of Agriculture and DPS are going to be authorized to collect samples from your crop upon inspection. So you got to be aware of the fact that this is going to be completely transparent. Compliance is going to be key. Testing. There could be 3 types of labs that are authorized by the bill. We're going to have state labs, we're going to have institutions of higher education, we're going to have private accredited labs. I think the private accredited labs are going to be the really interesting one, but that's for another day. License holders will select the labs that conduct their testing for them. License holders cannot own any of the lab, the exception being a cap of 10% on a publicly traded entity. The license holder is going to pay for the testing, so it's going to be up to you. That's why I think the private labs are going to be instrumental, because there's going to be competition. I do think lab testing will go down in time, and we'll find private labs. The important thing about the private labs is House Bill 1325 specifically dictates that an accredited lab that's accredited by the state will accept its lab testing results as valid. Results will be due within 14 days, and your private labs must be ISO IEC 17025 accredited. That's the accreditation standard that's been propagated. It'll be up to the labs to comply. That'll be part of their accreditation procedure. Pre-harvest testing is going to be mandatory. You cannot harvest without your products being sampled. If your crop has not been sampled, you cannot cut it down, you cannot harvest it. It's going to be required that samples be taken from at least 5 plants within the plot. It's going to be randomly sampled, and the state has to collect it. As you'll notice, the department must collect the samples. Now, sampling has to be done within 20 days of your anticipated harvest. So it's going to be up to the grower to notify the state of their anticipated harvest date, and then state will set up, come sample. There's nothing that'll prohibit a grower from harvesting immediately upon sampling. As soon as it's done, you can cut them down, but it has to be done within 20 days of the sampling. You cannot sell harvest, you cannot process the harvest until you have a passing test result. Now, what happens if your test results come back and you fail? Well, you're provided a single post-harvest test. That's part of the appeals process, the due process that they're required to provide. You have to request it within 15 days of notification of your fail. So they've got 14 days to give you results, notify you that you fail. From that day that you're notified, you'll have 15 days to request post-harvest testing. Post-harvest testing will involve sampling the products, testing it post-harvest after they've been dried, cured, and are ready. Now, if you pass your post-harvest test, then you're good to go and you can market the products, that your crops can be sold. If you fail, then you have 2 options. There are remedial measures. We can trim the plants to bring them into compliance. We can continue to try to work them into compliance, or we can destroy them as prescribed by the U.S. Code. There's an entire procedure that lays that out. Ideally, I do believe everybody will take remedial measures if necessary, simply from an economic standpoint. Talk about seeds. We got to start plants from somewhere. The Department of Agriculture is going to be in charge of certifying seeds. Interestingly enough, just this week, the Oregon Department of Agriculture, in conjunction with Oregon State, announced the largest project in the entire country for certifying seeds. Why is that going to be important? Port 3. They may authorize the importation of seeds from other jurisdictions, that's states or foreign. I do believe Oregon potentially is going to be a huge supplier, as well as Colorado. The state can also partner with private groups, but like I said, I think you're going to see them just partnering, for instance, with Oregon State University. The state's also obligated under the bill to produce a list of certified seed suppliers, places that farmers can reliably get seeds to grow. And they have to make it available to the public. Now, you cannot sell, use, or distribute seeds that are not certified. So there is going to be a little bit of time for this to all work out before seeds are going in the ground in Texas because of that provision. Transportation. We've got to move products around. It's going to be a very important issue. The state's going to issue a shipping certificate. That shipping certificate is going to have a manifest. Manifest is going to be very specific as to the cargo, and it's going to have a unique identifier specific to that shipment. Hemp shipments will contain hemp only. You cannot commingle products. Nothing else can be shipped with them. The documents that'll go with your shipments must specify the origin. I cannot stress this enough. Must be very specific. We must have chain of custody. These products must be legit. I would suggest that they will likely be transported where and when possible with the lab results as well. Now, peace officers, that is law enforcement in the state of Texas, do have the authority to stop and inspect any and all hemp shipments. They can sample and they can detain if the proper paperwork is not there. Now, without probable cause that a crime is being committed, they cannot seize the plant material. And that's going to be important as far as spoliation is concerned. Your plants will move, but to avert these problems, we need to have our documents in order. Now, as I said, there's two types of products. You have your non-consumables and you have your consumables under Texas law. Your non-consumables are covered by the Agriculture Code. Your consumables will be covered by 443 of the Health and Safety Code, but we'll talk about that in a minute. Non-consumables are your paint, your cloths, fiber, paper, rope, all of these products that are not meant for consumption. Consumables are going to be your foods, your cosmetics, any drugs containing CBD, things that are meant for human consumption, as well as there is a caveat for animal feed. That's its own little extra bit. Non-consumable products cannot be prohibited. They don't require a grower's license to manufacture. What's very important, there will be no smokable products. That includes vaping as well as flowers for smoking. No state agency can authorize this. So we've already seen them on the market. We're seeing them pop up. Those are not allowed. Non-consumable products are legal to manufacture. They're legal to possess, transport, sell, and purchase as well. Interesting for retailers, anyone involved as vendors, the department must provide you reasonable notice of any violation and the opportunity to remedy or mitigate any of your violations. So we don't anticipate you're going to have doors getting kicked down or SWAT raids. Out-of-state products, if they were legal where they originate from, are going to be allowed, are perfectly legal, as well as the products produced here in Texas can be exported to other states. Consumable products, as I said, are going to be covered by Health and Safety Code 443. Food, drugs, cosmetics containing CBD or other hemp-derived cannabinoids are your bird's eye view definition. They require specifically a license to produce. The requirements for those licenses are very similar. You can't have a felony controlled substance conviction within 10 years. The license will be denied if you falsify any of the information. And you must give consent to enter and inspect your facilities. Your license will be valid for 1 year and then will be renewable, but these are going to be subject, I would suspect, to much more strict scrutiny than we're going to get in the industrial non-consumable market. Testing of consumables is going to be much more extensive than what's required for non-consumables. All of your testing is going to be carried out before plants can even be processed. You must test for the concentrations and the cannabinoids. We want to know what we're consuming. They're also going to test very specifically for heavy metals, pesticides, any residual solvents from production, as well as microorganisms and pests. Specifically, it is outlawed to have any of those. It remains to be seen what specifically the state is going to list as far as what thresholds are going to be allowed, but we do know, for instance, Eagle 20 is not going to be allowed. Retail sales. Everyone wants to sell it. It's interesting, the state's going to set up a registry of places that sell CBD. You're going to be required to register to sell CBD oil, even though it's a wide open market right now. You cannot sell CBD products that have not been tested, and there's also provision that the state is going to start sampling at random off the store shelves. The department, again, must give retailers notice of any violation before they can seek enforcement. Out-of-state products as well will be allowed. Packaging. Packaging is going to be specific as far as what's required. Picture here is absolutely non-compliant. You're going to have a batch identifier, batch date. Those are your production requirements. Then you're going to have your product name, obviously. Your brand will be on the front of your product. Interesting that we're going to require a URL or a QR code that'll go specifically to your analysis certificate for your chemical analysis of your batch. You also have to have manufacturer's name and a statement of compliance that these products are in compliance with the laws of Texas before they can be sold. So now you know a little bit about House Bill 1325. Please feel free to reach out to us at 888-DOPE-420. That's 888-367-3420. If we can be of any assistance moving forward, we look forward to working with the Texas hemp industry. Thank you.